Good day. So, our topic is about if prisoners deserve the rights to vote. But before that, we of course have to answer first the question of why is this topic significant? From the book Citizen Convicts, Prisoners, Politics, and the Vote by Cormac Behan, the debate about prison enfranchisement is significant because it gives us some insights into the objectives of imprisonment, the society's conflicted attitude towards prisoners, the nature of democracy, and the concept of citizenship. This book also says that in a democratic polity, the deliberate denial of the right to vote to any section of the population has very serious implications, both symbolic in terms of devaluing citizenship and practical in terms of affecting electoral outcomes. Also, civil and political rights is one of the aspects of human rights, as for United Nations Human Rights Office of the High Commissioner. According to the Article 25 of the International Covenant on Civil and Political Rights, every citizen shall have the right and the opportunity, without any of the distinctions mentioned in its Article 2, and without unreasonable restrictions to a. Take part in the conduct of public affairs directly or through freely chosen representatives. B. To vote and to be elected at genuine periodic elections, which shall be by universal and equal suffrage and shall be held by secret ballot, guaranteeing the free expression of the will of the electors. And lastly, C. To have access on general terms of equality to public service in his country. Therefore, the prisoners as humans and as citizens of the country deserve the rights to vote.
Prisoners are still valid for voting rights because whether we like it or not, they are still part of our society. As a part of it, they have the responsibility and rights to choose who they want to lead the place they're living in, especially here in our democratic country, the Philippines. We still have to consider the prisoners' vote because every votes are as important as the other. As for the Most Reverend Pablo Virgilio David, Doctor of Divinity, President of Catholic Bishops' Conference of the Philippines, Bishop of Caloocan, every vote of every citizen is important because it is a concrete expression of participation in politics of our country, it is a right protected by our Constitution, it is the result of our ancestors' sacrifices who fought for our freedom and democracy, and it is an opportunity to choose those candidates deserving of government position as public servants whom we entrust the future of our country to.
Furthermore, from the Article 5, Section 1 of the 1987 Constitution of the Philippines states that suffrage may be exercised by all citizens of the Philippines, not otherwise disqualified by law, who are at least 18 years of age and who shall have resided in the Philippines for at least 1 year and in the place wherein they propose to vote for at least 6 months immediately preceding the elections. No literacy, property, or other substantive requirements shall be imposed on this exercise of suffrage.
Now we heard unless disqualified by the law, we can associate it with the detained individuals. Factually speaking, there are still qualifications for detainee voting just for the liberated people. From the resolution number 9731 issued by COMELEC, the PDLs or the persons deprived of liberty who are allowed to vote are the following. First, those confined in jail, formally charged in any crime, and awaiting or undergoing trials. Second, those serving sentence of imprisonment for less than 1 year. And lastly, those whose conviction is on appeal.
Meanwhile, from the Article 12, Section 118 of the Omnibus Election Code of the Philippines, the disqualifications of a voter as follows. First, any person who has been sentenced by final judgment to suffer imprisonment for not less than 1 year, such disability not having removed by plenary pardon or granted amnesty, provided, however, that any person disqualified to vote under this paragraph shall automatically reacquire the right to vote upon expiration of 5 years after service of sentence.
The second disqualification is any person who has been adjudged by final judgment by competent court or tribunal of having committed any crime involving disloyalty to the jury, constituted government such as rebellion, sedition, violation of the anti-subversion and firearms laws, or any crime against national security, unless restored to his full civil and political rights in accordance with law, provided that he shall regain his right to vote automatically upon expiration of 5 years after service of servants.
According to the publication of Center for Crime and Justice Studies, the principal argument in favor of enfranchisement is that it recognizes that prisoners remain citizens while incarcerated and marks their inclusion in society. Without the vote, they remain in a state of civil death, which if we realize is ironic to the democratic concept of our country, as well as embedded enfranchisement to the citizens in the human rights standards.
From this, therefore, enfranchising prisoners could stimulate debate on penal reform as well demonstrate a commitment to human and civil right and democratic reform. The other benefits that comes along with this promoting civil responsibility, from which the PDLS will see themselves as law-abiding citizens, useful, responsible, and trusted. And those are the justification of why prisoners are still deserving of voting rights.